It's an interesting thing to be called influential. It's most definitely an honor. But what does influence mean? Development or behavior of someone or something. To have an effect. That's not only an honor, it's a significant responsibility. How we use that matters. Who and what we stand up for and what we stay silent about, what we monetize versus what we actually live matters.
Hey besties, welcome back to my channel. Well, the contract has been unsealed, and this is a doozy, and this will change the game for Blake Lively. Within this actor agreement, which was drafted in May of 2023, in which Lively formalized by signing her 17-point agreement in November, while this specific document is not signed, her 17-point agreement incorporates it. And with that, that means everything that's in this contract is enforceable. Both parties have acknowledged this in open court. Wayfarer has now provided this to the judge, and it changes the game completely. Blake Lively, under the terms of this contract, is not allowed to sue Justin Baldoni, Wayfarer, or anyone. She agreed to arbitration. This entire contract is wild, because some of the parts of this contract are actually pretty standard. There are standard conditions within this contract, but there are stipulations within this contract that actually require Justin to have conversations with her about scenes under the terms of her contract, including those that required any level of undress or intimacy. Under the terms of her contract, he had to speak to her ahead of time and get her consent. So conversations about what would be in the film and how to choreograph scenes were required under her contract. That was something she sought out. But let's kind of dive into why this whole thing turns this all upside down and how this will eventually and could eventually cause serious issues. There's been a lot of questions, first and foremost, about whether or not this contract not being signed matters. And I'll tell you why it doesn't, because as of November 15th, 2023, she had a document sent to them that was an amendment to her list of protections she wanted, okay? It says reference is made to the certain agreement dated May 5th, 2023 between It Ends With Us Movie LLC and Blakely for the acting and related services of Blake Lively in connection with the motion picture. The parties wish to confirm the conditions under which lender has agreed to cause artists to render acting services on the picture following the break in production of the picture related to the 2023 labor strikes. Now, therefore, for good and valuable consideration, the receipt of which is hereby acknowledged, company agrees to the following additional terms and conditions in connection with the artist's services and use of the artist's results and proceeds in the picture, which shall be deemed incorporated into the agreement. Those beginning contracts acknowledge that there is an actor's agreement, which was dated on May 5th. It acknowledges that this side amendment is only being done after the strike and incorporated into that agreement. She is acknowledging that this is only a part of the contract and that contract is also bound, and she was bound to. This contract, the November 2023, had nothing about compensation. So in order to get paid and get bonuses, she had to agree to the terms of the actor's agreement. And she was paid. And because she was paid and the project was completed, she accepted the contract, whether she actually signed it or not. So I want to dive into the actual contract that she signs. And there's a lot here, but to be as clear, as concise as possible, there's been a lot that she has made in her complaints, lots of allegations that she has made. One of them specifically related to COVID. She accused them of exposing her to COVID because they had no protocols. But this contract references COVID multiple times and also has an agreement within there about COVID that she acknowledges in a separate portion of the contract as an amendment. So the concept that they had no COVID protocols would be false because it says that the company's receipt of lender and artist's signature to the company's COVID safety protocols and regulations acknowledgement, which is attached here too. There was an attachment in this contract about COVID specifically. And it said that Blake acknowledged and agreed that the movie has provided the COVID safety protocols and regulations that should be followed while I am providing services in connection with the motion picture currently entitled. So she had to follow their guidelines. Furthermore, I acknowledge and agree that I will use reasonable good faith efforts to follow guidelines in the COVID safety regulations. Ad may be amended from time to time. I will follow any reasonable written instructions provided by the company with respect thereto, to including, if required, the completion of a daily health declaration before commencing work. Repeated failure to follow the COVID safety regulations may be deemed a breach of my agreement in connection with the picture. And the company acknowledges and agrees that the COVID safety regulations are in line with government regulations and guidelines and have been approved by SAG. They had COVID protocols. She didn't sign this, but she signed the 17-point agreement, which incorporated this entire contract. So for her to state that there were no COVID guidelines is false. In her amended complaint, Blake falsely accuses Baldoni of not implementing COVID protocols. Mr. Baldoni, on page 38, Mr. Baldoni and Mr. Heath failed to implement COVID protocols when there was a COVID outbreak on set. Miss Lively was told by another producer that because Wayfarer did not have insurance coverage for COVID, Mr. Baldoni and Mr. Heath deliberately withheld from Miss Lively that she had been exposed to COVID. Both Miss Lively and her infant son contracted COVID from the outbreak. She makes this claim with no proof, by the way. And there was absolutely a COVID protocol. And her contract specifically states that they had insurance, period. Okay. The standard conditions, which is Exhibit A of her contract, specifically references having insurance. And it says the company shall have the right to apply for and take out at company's expense life, health, accident, cast, and other insurance covering the artist in any amount company deems necessary to protect the company's interest hereunder. Artist shall not have any right, title, or interest in or to such insurance. Artist shall assist the company in obtaining such insurance by submitting to usual and customary medical and other examinations, by signing such applications, statements, and other instruments may be reasonably required by any insurance company, provided, however, that the artist may have artist's own physician present. If artist so requests, provided that such physician does not interfere with the examination conducted by the company's physician. In the event that the artist fails or are unable to qualify for such insurance at customary rates and subject only to customary exclusions and deductible amounts, the company shall have the right to terminate this agreement, provided, however, that if termination of this agreement is only a matter of a higher premium or increased deductible, artists shall have the right to avoid such termination by paying such additional premiums or any increased deductible as applicable. As a result of the insurance that they had, and she knew they had because it was in her contract, she was also barred from taking private jets. I wonder how many times she used private jets during the filming. Probably a lot. There's also another part in this here that might pique your interest a little bit, and it has to do specifically with legally. Can she even sue? The answer is a flat out no. One of Wayfarer's affirmative defenses is that Blake has waived her rights and has stopped from suing Wayfarer. And that is because she agreed on under standards Exhibit A under 15.2 legal proceedings and arbitration. It says the parties agree that except as otherwise required by any applicable guild collective bargaining agreement, any and all disputes or controversies of any nature between them arising at any time, whether or not relating to the picture, shall be determined by binding arbitration according to the rules of JAMS or other agreements and parties, held in Los Angeles, California, before a single neutral arbitrator. The arbitrator shall be an attorney with at least 10 years of experience in the motion picture industry or a retired judge and shall be mutually agreed upon by company and lender. If company and lender are unable to agree on the arbitrator shall be appointed by the arbitration services. The fees of the arbitrator shall be borne equally by the company and lender, provided that the arbitrator may require such fees to be borne in such manner. The party shall be entitled to conduct discovery in accordance with Section 1283.05 of the California Code of Civil Procedure, provided that the arbitrator must authorize all such discovery in advance based on the findings that material sought is relevant to the issues. Discovery shall be limited to depositions and production of documents unless the arbitrator finds that another method of discovery is most reasonable. There shall be a record of the proceedings at the arbitration hearing, and the arbitrator shall issue a statement decision setting forth the factual and legal basis for their decision. If neither party gives written notice requesting an appeal within 10 business days after the issue of the statement of decision, the arbitrator's decision shall be final. Arbitrator's decision may be enforced by a petition to the Superior Court for confirmation and enforcement of the award if either party gives written notice. This goes into very strict detail that they could and had to manage all disputes through arbitration that had to do with the film or outside of the film. And then under this arbitration clause, it states that everything needs to be closed to the public and confidential, and all records relating it shall be permanently sealed except as necessary to contain court confirmation of the arbitration award in accordance with the provisions. The fact that there is a dispute between parties that is the subject of arbitration should also be confidential, and neither party shall be disclose, report, reveal, gossip, or speculate about any arbitration by any means, including without limitation by email, blogging, or tweeting. And it says that paragraph 15.2 shall supersede any inconsistent provisions of any prior agreements between the parties. In 2022, a law was passed which was called Ending Forced Arbitration of Sexual Assault and Sexual Harassment by the federal government. Basically, what this law does, it invalidates arbitration agreements for sexual assault and harassment claims, allowing individuals to choose between court and arbitration for disputes, regardless of the parties' relationships, which includes business to business and contracts and special employers. The act protects all individuals, including customers, vendors, or contractors who might otherwise be bound by mandatory arbitration clauses, but it's only for sexual harassment or sexual assault. And these only apply to the employer that she's in an employment relationship with. Her contract very clearly states that her relationship is not between her and Wayfarer. In fact, there is no place in this 30-some pages that it says anything about Wayfarer Studios. The entire contract is between Blake and it ends with Us Movie LLC, period. There's no Wayfarer listed on here. So because she's got this arbitration clause, Blake cannot bring claims against Wayfarer or it ends with Us Movie LLC that are related to defamation, that are related to breaches of contract, that are related to civil conspiracy, defamation per se, invasion of privacy, false light, any of those. Because under the law and under her contract, she's agreed to go to arbitration. Because the other unsealed document makes clear that when Blake filed this lawsuit and provided a copy of the agreement of the right to sue notice that she received, it ends with Us LLC, as I've told you a million times, was excluded from the letter that she sent to Wayfarer and served on them after she filed the notice. She never included It Ends With Us Movie LLC on that document, and she did not exhaust her administrative options by including them. And her contract makes clear that the contract is with her company, Blakel Inc., and It Ends With Us Movie LLC. She cannot go after the fact and claim that she has changed or altered this because her third or second amended complaint states that the December 20th CRD is the one that she's using for the complaint. So remedying it now doesn't change anything. Blake has stated in her lawsuit that she also was given the cut to edit the film and release the film by Sony. In fact, she was told, that's what she said. She led Sony's cut. But her actual rights under this contract do not give her the right to edit or do any of such things that she did as a part of this. In fact, she was 100% given a vanity credit, which says, in addition, artists shall be accorded one executive producer credit in the first position in the main titles where the individual credits for the principal cast, whether located at the beginning or end of the picture, and in the billing block and all paid ads and excluded ads, in size, type, style, manner, and duration no less favorable than any other executive producer credits. That's all. It was a simple credit. She was not given any other responsibilities in this contract other than she was given the vanity credit. Okay. She was paid $1.75 million on a pay to play basis. And then she had the opportunity to receive up to $1.2 million in bonuses, and additional bonuses were awarded if she were to get, say, nominated for awards. Okay. They did and made a ton of accommodations for her for ground transportation, travel, giving her per diem. They even paid for her to have an assistant on the set. As a part of her publicity, there's a publicity limitation, and any publicity she did had to get approved by Wayfarer, okay, under this contract. It says here that no publicity issued by the lender and artist, whether personal publicity or otherwise, shall contain derogatory mention of the company, the picture, or the services of artist or other in connection with the picture. Lender and artist may not disclose any confidential information not otherwise available to the public with respect to the company or the picture, without company's prior consent, except for information disclosed to the lender and artist's agents, attorneys, and business representatives. She had mutual approval over the first press release when they announced that she was being picked up as the actress. They said that they would not take anything to the tabloids. So it says, beyond being mentioned as an actor in the picture, company shall provide 24-hour notice to the artist of press on set and or any behind the scenes or B-roll filming, provided the company's inadvertent failure to provide such notice, the artist shall be deemed in breach of the agreement. Shall not be deemed in breach of the agreement. Company shall not submit to tabloids. Artist acknowledges that company cannot make any guarantees regarding the unauthorized use of stills, renditions, or press junket footage by publications or media outlets which were legitimately serviced by company's publicity department during the nominal course of publicizing and promoting the picture. Any publicity and promotional services shall be coordinated with the artist and the artist's representation, so to minimize interference with production, provided artists shall be available for reasonable number of on-set interviews. And then, so when it comes to publicity, she was prohibited from speaking negatively or leaking anything about this production to the press without their approval, which directly goes against Leslie Sloan leaking to the press about Baldoni, about what was happening on the set. That's a breach of contract on her end. There's this part here that's been well discussed by Brian Friedman, and it has to do with being frustrated. So she has exercise of consultation and or approval rights. So this is the control she was given, which isn't much. All consultation and or approval rights, if any, granted to lender and artist shall be subject to the following. Lender and artist being available as when and where reasonably required for the exercise of such rights being exercised in a reasonable manner, and so not to frustrate the company's full and timely development, production, and or exploitation of the picture. So she was allowed to give input, but she could not get in the way or stand in the way of them releasing this. Such rights are personal to lender and artist and may not be exercised by any other person or entity. So it was only for her, not for Ryan, for anyone else, and are subject to artists' full performance of material services and artists not being terminated by default. But under that, the company's determination shall be final with respect to any matter or with respect to which the lender and artist have consultation rights hereunder. The company shall not be obligated to incur any additional costs with respect to such consultation or approval rights. She has mutual approval on hair, which was Ann Carroll, makeup with Vivian Baker, which was pre-approved, wardrobe personnel, and a wig maker. That's right, friends, she wore a wig. Stand-in and body stunt double, if any, and the final screenplay, which artist hereby approves. Director, which she pre-approved, which was Justin, and or his replacement, and the co-lead of the picture, Justin, which she pre-approved, and any replacement therein. She will be allowed to have consultation over the look for the role, the ad campaign in which the artist appears, and the release of the pattern of the picture, provided that the company's final decision shall control in each instance, and the distributor's final decisions shall control in each instance with respect to the ad campaign in which the artist appears and the release pattern of the picture. So they had to consult with her on like things like her hair, her look, her makeup, her wardrobe, and she agreed to the script when this was executed in May. Okay. So she didn't have rights to edit. She didn't have rights to cut. She didn't have rights to the dailies. She didn't have rights to how the film would be made. And there's nothing in here that says that she has any right to control what the picture looks like at the end. She claims that she had led Sony's cut, but her contract says she doesn't have the right to do that. Blake absolutely lied in her complaint on page 38 of the first or second amended, where it says that Wayfarer failed to provide Miss Lively with even rudimentary employment protections, such as an employee handbook, a sexual harassment policy, information, or any training on sexual harassment, discrimination, or respectful workplace activities. This is actually 100% false because there's a specific carve out in her actual contract about sexual harassment. It says sexual harassment of any type is strictly prohibited and cause for immediate termination of this agreement by the company. No employee shall be subjected to sexual harassment by another employee during the course of employment. For the purpose of this policy, sexual harassment is unwanted conduct of a sexual nature which adversely affects another person's conditions of employment and or employment environment. Such harassment includes, but is not limited to, any unwelcome sexual advance, request for sexual favor, or other verbal, nonverbal, or physical conduct of a sexual nature that interferes with work, is made a condition of an employment, or creates an intimidating, hostile, or offensive environment in connection with the workplace, or the use of one's authority or power, either explicitly or implicitly, to coerce another into unwanted sexual relations or to punish another for his or her refusal. For the avoidance of doubt, sexual harassment may occur between and amongst persons of different sexes or genders, or the same sex or gender, and may be initiated by any gender or sex. In the event company is aware of sexual harassment conducted by artist, they have the right to immediately terminate this agreement, available to all rights and remedies hereunder. She was made well aware of what sexual harassment was, or if they found out that she sexually harassed anyone, they could fire her. We know from their now dismissed claims that they did have a workshop on safe work environments, which included information about sexual harassment and how to report. So it was not only included in her contract, but it was also included in the week they started production. She also has a morality clause, and that says that she warrants and represents that prior to the date of this agreement, she does not and has not been convicted of any act or acts of moral turpitude, which might violate community standards of viewers and advertisers in the United States, and if publicly revealed, would result in widespread public disrepute for the artist, company, or its assignees, designees, distributors, programming services, sponsors, or subject them to scandal and ridicule. So it's a very broad morality clause, and that if she doesn't disclose it to them, she can be fired. If she's convicted of something, she can be fired. It basically says she needs to keep herself clean so that she doesn't embarrass the company. In terms of her ability to hire another editor or to hire a composer, she does not have the right or authority and shall not employ any person in any capacity for the purchase or rental of any article or material or make any commitment, agreement, or obligation whereby company shall be required to pay any monies or other considerations without the company's prior written consent. They had insurance, they had workers' compensation. The amount of lying that this woman has done and is clear they had in this contract and how extensive this contract was is bananas. Limitations on damages. Check this out. In no event will any party, company, or artist be liable for or have any obligation to pay to the other consequential and or incidental or special and or punitive damages, all of which are expressly excluded, and company and lender and artist hereby waive any right to recover any such damages from the other. She's barred from special and or punitive damages, which kind of flies in the face of the whole 47.1 that she can't bring in the state of New York. And the other point I talked about yesterday is I wanted to know about the NDA. And there's an entire confidentiality clause at the very end, and it's a strict non-disclosure agreement. It protects all production information, which are scripts, storylines, filming details, and character information. It prevents the artist or her team from publicly discussing, describing, or dramatizing anything related to the film, the company, or her services. It's a total confidentiality requirement, which neither the lender or artist, the lender is her company and the artist is her, so neither lender nor artist shall disclose, report, reveal, gossip, or speculate about production information by email, blogging, or tweeting. She and her company were absolutely prohibited from talking about production details publicly, posting or hinting online about behind-the-scenes events, sharing scripts, communication schedules, or storyline. She was not allowed to do any of those things without prior written consent. And so anytime Leslie was running to the press about this, that's a violation. Companies shall have exclusive right to release production information and determine under what circumstances to release it. So the studio has exclusive control over when the public hears information about the movie, what information is shared, and who releases it. If she wants to do an interview, post, or even acknowledge something about the film, she has to have their written approval unless it's personal publicity and it's unrelated to the movie. Any work, material that she makes or compiles shall be deemed to be part of the results and proceeds and a work made for hire for company. So anything that she does for this film belongs to the studio. She can only discuss the project with her attorneys, agents, or representatives, and even then only as necessary or under subpoena. And the information that relates to production information is all information relating to artist services, the picture, its production and exploitation, the screenplay, the storylines, the characters, the budget, the schedule, the production plans, the drawings, the designs, the specifications, ideas, and the concepts. Essentially everything that connects to the film, including content, production, logistics, financial details, creative concepts, marketing, and distribution plans are covered under the NDA. And her confidentiality clause forbids gossip, speculation, or disclosure. Disclose, report, reveal, gossip, or speculate by any means without including but not limited to email, blogging, or tweeting, private conversations in person or text. It could mean group messages with cast or crew, post links through sources to the press. So even if she's talking about true claims, whether true or not, about what happened and how she felt she was treated, even privately, she's controlling and she's disclosing production information to people that don't need to know that information. It's also a breach of the non-derogatory limitation within her section where it says that she will not speak about production in a derogatory manner. That means she's not allowed to make comments or encourage others to view the company, the director, or the project as negatively. So that's why Justin, I think, is so focused on how she's turning everyone against him. And if she was doing that, that could actually be looked at as retaliation against the film. So she's influencing witnesses or discouraging cooperation, or she's damaging the ability for the film to defend themselves. So disclosure alone is a violation. So she has violated this so many ways to Tuesday. It's pretty wild. And, that would include her conversations with Taylor Swift and even her husband, for crying out loud. I mean, this is a very tight NDA. The last part I'm going to share with you today, and we'll talk about this contract in more detail, that this is a very high level, but one detail in here has to do with the simulated sex scenes and the nudity. And one of her complaints was that, Justin and Jamie had to talk with her and consult with her about the birth scene and about, what they envisioned for the birth scene. They also had to talk with her about, what they were going to do for the choreography for the simulated sex scenes. In her contract, it says, no nudity, no simulated sex scene. Artists shall not appear nude or be required to film any scenes in the nude to appear in any simulated sex scenes without obtaining artist's prior written consent. Company agrees not to use any body double to simulate artist's appearance in the nude or any simulated sex scenes without obtaining artist's prior written consent. Further, companies shall not digitize artist in any manner to simulate artist's appearance in the nude or in any simulated sex scenes without obtaining her prior written consent. This meant she had full approval over sex scenes and how she would be in these. And anything that included her looking nude, she had to be approved of. Any sex scenes had to be approved by her. So how does a director then discuss what they want to do or what someone has told them for that scene? There were scenes that were written into the film. She said she wasn't going to appear nude in any of the sex scenes, right? No body doubles could appear in the sex scenes. She was never nude in any of the sex scenes, but they had to talk to her about it for any of these scenes. Meaning, if she has to talk to, if they have to have conversations with her about it, if she's going to appear nude or if she might appear less undressed, they have to ask her if she'll do it. It's a conversation that has to be had under her contract terms. And now she's weaponizing those contracts that they were required under her contract to have with her as sexual harassment. It's wild, honestly. So what we learned is that when Blake sued, she sent them a right to sue notice. They did not include the company that was her employer. Per her own contract, she acknowledged that her special employer was what Ends With Us Movie LLC. Wayfarer was never her employer, ever. We learn that there's an arbitration clause in this, meaning any claims outside of sexual harassment, which she can still bring to the court because of that law from 2022. But because of that law and because of federal law, she has to get a federal right to sue for the company that was her employer, which she never obtained, which is why Wayfarer is saying she never got it with It Ends With Us movie. Got it? She agreed to the script as it was. She agreed that Justin would be the director. She wore wigs. She had a strict non-disclosure conversation. She did not have rights to edit. She was not given a PGA credit. Her credit did not give her authority over any of the scheduling information. She wasn't given rights to do filming schedules, to hire anyone. She couldn't hire anyone without their approval. Blake has claimed publicly that she was given the right to do all of these things because she was the PGA producer, and there's nothing in her contract that says she gets to do any of those things. And then she weaponized sexual harassment and brought a lawsuit to court that under the law or under the contract, she was supposed to arbitrate, specifically the breach of contract. If we just had the meat of this where it was just breach of contract, say the judge throws out everything else, under her own rule, under their contract, she has to abide by that and arbitrate. And again, this doesn't matter if it's signed or not because she was paid. And in order to get paid, it means you agreed to the terms. The project was complete. She acknowledges the contract in her 17-point agreement. She incorporated that into the agreement. So as far as from a legal perspective, this was a signed contract. No one is disagreeing about the contents of this contract. No one is disagreeing that it exists, signed or not. She can't sue for defamation. She can't sue for breach of contract. She can't sue for false light. But Blake did invade their privacy, and Blake did gossip about them. And honestly, Wayfarer filed a countersuit outside of the arbitration agreement. It's actually just wild. Blake's case is falling apart. And I told you that they wouldn't have unsealed this if it wasn't for a reason. And this is why it's been unsealed. She has no basis for this lawsuit, and now she's exposed. Tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.